One of the arguments made to allow the use of waterboarding on detainees accused of terrorism is that since they are not defined as lawful combatants under Article 4 of the Geneva Convention, they do not deserve the same privileges. Given that, do you think it would be reasonable for another country to subject American members of private military corporations, such as Blackwater, to the same treatment since they are not defined as lawful combatants under the same article?
Unfortunately, in every war that we've fought since World War II, our captured servicemen have been abused by the enemy because it's part of the asymmetric warfare that they wage against us, regardless of whether we have, what our policies have been. The other thing I'll say is that I think Al-Qaeda has no intention of taking any prisoners, and they have no intention of treating anybody with any humanity. They actually, as far as we know, deliberately tried to capture and kill civilians. And they were trying to do that before 9/11. And they did it after 9/11, regardless of what American policy is. The question, do we really think that our policies on interrogation are going to make any difference in the way Al-Qaeda treats our soldiers who have fallen into their hands? Instead, I would say that what we ought to be worried about is a conflict against another country, say China or Russia, and how they treat our soldiers. And so the important thing is to make sure that we have some kind of reciprocal agreements with them about how we treat captured soldiers in those kinds of conflicts. But I'm afraid, by the way Al-Qaeda has acted, it's fanciful to believe that our conduct is going to have any effect on the sort of brutal methods they use to try to defeat us.
The people of the world, we issue a citizen's arrest against John Yoo, right? Good and
We need to finish up these questions in a few minutes. This one is directed to Professor Rosenthal. Doesn't Professor Yoo's memo on the Fourth Amendment specifically state that the Posse Comitatus Act remains in force and the act prevents the use of armed forces in policing on U.S. soil? Shouldn't the President be able to act quickly when reasonable and without a warrant when an attack is actually happening on U.S. soil?
It goes too far. The memo doesn't say things like the President can do whatever he wants. The memo doesn't say the President's above the law. The memo doesn't say Bush can do whatever he wants. I mean, again, you can take a look at the memo, or you could selectively put things, or you can just put things into the memos that aren't even in there. The memo actually says that the Posse Comitatus Act, which is a bar on the military pursuing law enforcement functions within the United States, has an exception for when either Congress says you can or when the Constitution would allow you to. One of those exceptions, through many, many years of Justice Department opinions, is if the country were attacked. It seems to make a lot of sense. And when Congress passes a statute, as it did on September 18th, saying that the President's authorized to use force. Sometimes, unfortunately, that might involve activity within the United States. Think about the 9/11 attacks themselves. What if we've been lucky enough to know which airliners were actually headed into the World Trade Towers or into the Pentagon? I think, unfortunately, our leaders would have had to decide whether to use force to shoot them down. Right, that is military. I hate that we have to make these kinds of decisions. And Larry worries about trucks driving up to the Sears Tower. I had to be worried about airplanes crashing into buildings and nuclear weapons or biological weapons going off in our major cities. And unfortunately, as we learned on 9/11, we didn't have many military resources in the country that actually could stop those kinds of attacks on those days and the days after. When you look at that kind of situation, we didn't say, oh, Bush can do whatever, when the President can do it. We said the statute that Congress actually passed contains an exception that looks for this very situation. The other thing is this claim that the Take Care Clause means that the President has to enforce every statute. I think Dean Eastman has already exploded this myth. It means that someone hasn't read Marbury versus Madison. Because in Marbury versus Madison, the very case established judicial review, the Supreme Court itself says that no branch of the government has to obey an unconstitutional law. This is an area, unlike most areas, where there are no great cases that set out all the lines between the branches, a set of all the lines of what you can and cannot do. In wartime, practice and tradition has been to leave this up to the President and Congress to work out between themselves. And I'm afraid these kind of arguments, I'm not attaching any motivation to this. I'm just saying these kinds of arguments that we're hearing will return us to the kind of over-lawyered, timid argument that we had before 9/11 of both parties when it came to terrorism. Both parties pursued law enforcement, prosecution, FBI agents as a way to fight terrorism. And I'm afraid on 9/11 we learned at the cost of the lives of several thousands of our citizens that those tools were not enough to stop up here.